morning, one and all present here. I'm Ms. Shivangi Sinha, Assistant Professor, Bharati Vidyapeeth, New Law College, Pune, and Faculty Coordinator of Madhyasthta, the ADR Cell, would like to welcome our today's guest, Mr. Rana Sajjad. Sir has been a dual qualified lawyer licensed in New York and Pakistan, having over 15 years of experience of practicing law. His experience and expertise lies in the field of cross border transactions, commercial litigation, and domestic and international arbitration. He has acted as co counsel on international arbitration proceedings, including proceedings under the rules of International Chamber of Commerce, ICC, and the Dubai International Financial Centre, London, Court of International Arbitration, LCIA. It is our pleasure to have you, sir, and I'm sure that the students will surely benefit from this session.
Hi, my name is Rana Sajjad. Thank you once again for the opportunity to be here today. It's a pleasure to be here and present my views and share my thoughts on some important issues regarding alternative dispute resolution, commonly referred to as ADR. A lot of people talk about the future of ADR, the promise that it holds and offers for dispute resolution. Some people think it's controversial because of a variety of reasons, especially in the international context. But personally, I think that it holds a lot of promise because if you look at the docket congestion and the backlog of cases in courts around the world, as far as commercial and business disputes are concerned, I think it makes perfect sense for us to focus on ADR, to promote it, to have it widely adopted, because that will not only enhance access to justice, that will also help ease the burden on the courts. And I think personally, I fervently believe that in a lot of cases, it does not make sense for business and commercial disputes to be resolved by courts when you have options like arbitration and mediation. And now, of course, we also have ARB, and other variations of these two. So basically, I think these hold a lot of promise. And I think overall, there's an economic argument to be made for ADR as well. Because if disputes are resolved more efficiently, effectively, it saves people a lot of time and money. And if in the grand scheme of things, it ends up saving economies a lot of money as well. And from the standpoint of foreign investors, if there are effective ADR mechanisms within a certain jurisdiction, it does encourage investors to invest in that jurisdiction because they feel comfortable with how disputes will be resolved in the future. So I think I believe that ADR certainly will grow with time. And I think it's only depends on how quickly people embrace it, adopt it, because this is a reality we have to deal with, live with. And I think the earlier we get to understand it, the better. Thank you.
Thank you so much, sir, for explaining the topic so well. So we'll start off with the question-answer session. So as we know that how COVID-19 times have affected not just the other sectors of employment in the world, but even the dispute resolution mechanism that people have adopted and gone with. So how do you think arbitration proceedings fits within the COVID-19 times?
Yeah, of course, COVID-19 was totally unexpected, and but I think we humans underestimate our ability to adapt to the changing realities. And I think a lot of people have done a fantastic job of adapting to this new reality. In arbitration mediation, especially, you've heard of online virtual hearings, online virtual filings. I think it was only a matter of time. I think this would have happened perhaps 5-10 years down the line. But what COVID-19 has done is it has accelerated this entire process of online filing, online mediation, online arbitration, online ADR, generally speaking. So I think COVID-19, that's a sort of a dividend, a positive, so to speak, of the COVID-19, because it has helped us get to that position where we would have gone 5-10 years down the line. So I think ADR practitioners around the world, for the most part, have done a very good job of adapting to this reality. And the users of the service, the parties, generally speaking, are fairly comfortable with all these changes. So I think litigation, of course, I think has sort of taken a hit because of the lockdown. And I think especially in the developing world where a lot of countries haven't moved fast enough to have online filings and online hearings. But I think that is where ADR has done a very good job.
Thank you so much, sir, for the insightful answer. My next question is, arbitral proceedings are cost effective. Is it really a truth or a mere erroneous fact?
Good question. Thank you. Yeah, this is something which is the basis for controversy around the world, especially in the international setting. So I think there is no one straight answer to this. As we lawyers say a lot of times, it depends on the particular case. So generally speaking, arbitration is supposed to be more cost and time efficient. It's supposed to save parties time and money. Why? Because parties can design their own process. If they arbitrate through an institution, they follow a certain set of rules. There are clear timelines. There are no unnecessary delays, unlike court proceedings. So in that sense, it's supposed to be quicker. And it's also cost efficient because in litigation, of course, there's uncertainty regarding how long the proceedings will go on. Attorneys' fees are unpredictable at times, especially with hourly billing. And then, of course, your business could get hurt as well because of all the ongoing proceedings. So generally speaking, it's supposed to be cost and time efficient, but the reality sometimes is different, especially in international arbitration, because sometimes proceedings take longer than expected. So I'll give you an example. Sometimes agreeing on the appointment of an arbitrator takes a long time because there's a lot of back and forth. Parties don't agree on the particular person appointed as an arbitrator. So that can take a while. When it comes to document production, sometimes there could be delays. So a lot depends on how the arbitrator or the arbitral tribunal, that's in the case of a 3-member tribunal, how they run the proceedings, how they manage the proceedings. Some arbitrators are generally more strict about complying with the deadlines. Some are not so strict. So it depends on them. But what happens is if proceedings go on for a longer time, attorneys' fees increase. In some cases, the institution fees also vary. So let's say if you're having virtual hearings, that saves you a lot of time and money because you don't have to pay for a hearing. But if you have to have a physical in-person hearing, then the costs add up. So there are certain variables because of which, especially in international arbitration, sometimes it does not end up being that cost efficient. That said, international arbitration still is the most preferred dispute resolution mechanism for resolving international commercial investment disputes. And there's a reason for that. Even though in certain cases it costs more money, it is still the most neutral, most effective mechanism for parties because I think there are no alternatives as such.
Thank you so much, sir, for explaining so well. So usually as a student, theoretically, we do study the fact that ADR is more effective as compared to the conventional court system for resolving a dispute. So you being a professional, what do you think when you're practicing the ADR process for resolving disputes? Is ADR in reality, in the sense of practice, is more effective as compared to conventional court system when it comes to resolving the disputes?
Yeah, so it depends on what type of ADR you're referring to. So if you talk about arbitration is very similar to litigation in the sense that you have an arbitrator, whereas in litigation you have a judge who actually decides the dispute for you. So arbitrator essentially is like a judge, or arbitral tribunal is like a bench of judges. They decide the dispute for you, because of which one party wins, the other party loses, right? Our mediation is different. Mediation is also one form of ADR. In mediation, it's considered a win-win because parties agree on a settlement. They agree on the terms of the settlement. So what the mediator does is he or she facilitates the mediation. So in that sense, the result or the outcome of the mediation is a mediated settlement agreement, which is considered a win-win. So a lot of parties who actually end up mediating disputes, they say, okay, this was more effective. Had we gone to court, one party would have won the case, the other one would have lost the case, right? But so in the case of arbitration, it's similar. There's usually a winner and a loser, award creditor, award debtor, right? So it depends on how you look at it. But again, I think you raise the point of being effective. And referring to my previous answer, even though in some cases it costs more money, takes up more time, it's still considered more effective. And not to complicate, but international arbitration is also more effective because of the New York Convention. The New York Convention is a United Nations Convention on the enforcement of foreign arbitral awards. So once the arbitrator gives or renders an award, it still has to be enforced through courts because generally there is no voluntary compliance. I mean, yes, some parties do voluntarily comply with the decision and say, yes, we pay you money, we'll follow the directions. But in case there is no voluntary compliance, you have to go to a particular court to enforce the award. Now, New York Convention is recognized by and ratified by more than around 150 countries, because of which, if you have an award, you can have it enforced in a lot of different countries. Now, that's a luxury a lot of court judgments don't have. Now, for mediation, it is changing now because of the Singapore Convention, but a lot of countries have not adopted it yet. But arbitration has that one critical advantage over other mechanisms because of the New York Convention. So again, speaking to your point about being effective, I think those are the reasons. So it's not just cost and time. There are other factors to consider as well. What will we do with this decision? Can this actually be enforced? Can we actually get our money that the arbitrator has ordered? So I think there's a lot of these considerations which you have to consider to arrive at an answer of whether or not it is more effective. And I think it is more effective.
Thank you so much, sir, for explaining. My next question is, what is the scope of a private mediator to resolve dispute between the disputants?
Also, the scope of the mediator has to be clearly defined at the outset. So his job essentially is to lay the foundation of the proceedings. He or she explains what his role is, and his role, as mentioned earlier, is to facilitate, is to nudge, is to move the parties towards a settlement. He or she does not decide the dispute. He or she does not say, you have to pay this much money or you have to comply with this. He or she can't do that. So his or her job is to basically mediate. So what will happen is, so let's say the mediation session has started. The person will explain his role. He will lay the foundation, the groundwork, the rules, and then he will ask one party, generally, let's say the claimant, to submit their arguments or claim orally, and then the other party goes ahead, and then they have a discussion, right? The mediator can also have a private session, which is sometimes called a caucus, and speak with the private party privately, because in some cases party is not comfortable talking about their side, their position in front of the other party. They want to speak in private. Mediator can do that as well. But then, of course, I think that the underlying principle is the mediator has to act very fairly. So if the mediator spends, like say, 15 minutes in a private room with one party, he has to do the same for the other party, because otherwise he would not seem very neutral or fair, right? And then because mediation is considered something that is focused on the parties' interests, not really their legal positions. So he or she has to make sure he's looking out for the interests of both parties, because during the course of the mediation, if one party feels that the mediator is a bit biased or inclined to favor one party, that party could just walk away. So I don't know if you already know, but one of the elements of mediation is that it is not binding, which basically means that if you write in a contract that you will mediate your disputes, it is binding on you to attempt to mediate, to try to mediate, but it's not binding on you to actually fully and finally settle the dispute by mediation. So the upside of mediation, or the positive or advantage of mediation, is that it's very time and cost efficient. But the sort of one downside is that it's not binding. So a party 1 hour into the mediation or a few minutes into the mediation will say, I'm walking away. I don't want to do this. And they can do that. So which makes the mediator's job even more critical to come across as fair, independent, and somebody who's actually looking out for the interests of both parties.
Thank you so much, sir. So as we know that we are in times where ADR is moving ahead from being alternate dispute resolution to appropriate dispute resolution practice. So as per you, what are the problems and prospects to ADR when it comes to its future application in the dispute resolution mechanism?
Sure. So I think the term appropriate makes a lot of sense, right? And I think the context is that whatever suits a particular party, right? So it has to cater to the specific needs of a party. So you need flexibility so that they can have the dispute decided the way they want. In arbitration, of course, you have that freedom. You can pick a certain institution. You can have ad hoc arbitration. You can design your own rules. In mediation, also, you have a lot of flexibility in terms of the mediator, the venue, how long you want the proceedings to be. So I think if you look at it this way, that there are small disputes, and then there are medium-sized disputes and large disputes. So when you speak of an appropriate method, I think if a dispute is in the millions of dollars, parties still try to attempt to mediate if they can, because that can save them time and money. But eventually, if they cannot, to them the most appropriate method would be arbitration, because of some of the reasons I mentioned earlier. One being the New York Convention. They would say that if 150 countries have recognized the New York Convention, and the dispute amount is, let's say, $10 million, and we eventually have an award in that amount, it would be easier for us to enforce that award in more than one country where the assets of the other party are located. So whichever country has recognized the New York Convention and that country happens to have assets of the losing party, the winning party can actually go to all those countries and try to have that enforced. So they would think that is the most appropriate method. For a smaller dispute, they could say, it doesn't make sense for us to spend thousands of dollars paying the arbitral institution's fees, a lot more for the arbitrator. We might as well mediate. And mediation, a lot of people don't even have lawyers to represent them. So I think the appropriateness of the mechanism basically depends on, I think, the size of the dispute, preference of the parties, and also I think the experiences they've had in the past. Sometimes people haven't had good experience with a particular method. And also, I think their relationship with the other party. If it's a long-standing business relationship, some parties say, let's not arbitrate, let's amicably resolve it. Let's not even mediate. If that doesn't happen, then they can mediate. So you have to consider all these factors to then figure out which would be the most appropriate mechanism.
Thank you, sir. My next question is arbitration the best sort of ADR body to minimize the conventional court system proceedings?
See, again, depends on the size of the dispute, right? As I said, in the international context, I think international arbitration still is the most preferred mechanism. But when it comes to domestic disputes, mediation is a pretty good option as well. But I think mediation, the culture of mediation and the openness to mediation, I think that is sort of a question mark. A lot of jurisdictions are still not very open to mediation. So I think you need to build capacity, raise awareness about the importance of mediation, how it works. But I think courts will always be there, even for an arbitration. Even for an arbitration to be successful, during the course of the arbitration, you need a court to supervise. So let's say in international arbitration, the seat, you usually write a seat of arbitration in the contract, that the seat of arbitration, let's say it's London, or it's Beijing, or Singapore, or Dubai. And the purpose of that is that when the proceedings are being conducted, and during the course of the proceeding, let's say if you have to go to a court to stay, let's say to preserve the assets of the other party and file a stay application, or to freeze a bank account or something like that, an arbitral tribunal can only give directions. They can give an interim award, a partial award, but to enforce it, you still have to go to a court. So arbitration, cannot frankly work very effectively without the courts. There is always the need for the court. Ideally, you don't have to keep going to court for these interim measures or even for enforcement, but we don't live in an ideal world, and eventually you do need the courts to facilitate the process, not to obstruct the process. Unfortunately, what happens is that courts in some jurisdictions, they obstruct the process, they assume jurisdiction. But otherwise, I think there should be no sort of turf war, so to speak, between litigation and arbitration, between courts and arbitrators. They need to, or they generally should work together, because the ultimate goal is to ensure that whatever decision is given by the arbitrator, that has integrity and that is actually enforced. So I don't see a competition between courts and arbitral tribunals as such. But I think I can see in some countries there is that sentiment among courts where they think that we're superior or we're more effective. But I think they need to complement each other.
Thank you so much, sir. So as we know that most of the ADR processes are being used for resolving disputes related to commercial matters or business subject matters. So is it appropriate and justifiable for any country to ignore the process outlined by dispute settlement body of any global organization like World Trade Organization?
No, so it's if you have ratified it and you're a signatory, I think you should not disregard those rules. And again, there are other considerations as well. End of the day, you have to be part of the global community, and you can't live in isolation. International trade and foreign investment certainly have a lot of dividends, a lot of benefits. So I think if you do not follow certain mechanism, you do not follow certain set of rules, in the short term, that might seem very convenient, but I think in the long term, it can hurt you, because it's about your image as well. If a foreign investor or a trading partner thinks that your country or businesses from your country will not adhere to the rules and principles, will not comply with the certain protocols or principles, it will become difficult eventually for businesses of that particular country to do business with other countries, regardless of how many resources you have, how much potential you have. Eventually, it does hurt your image. So I think from that standpoint, also it doesn't make sense for any country to flout the rules of an international body such as WTO. I mean, I look at it this way: if you don't think that you have the capacity or the will to follow those rules, do not ratify it. Do not become a signatory in the first place. But if you have made that commitment, you need to honor it.
Thank you, sir. Moving towards another question. When can the courts interfere in the awards passed by arbitral tribunal?
Yeah, so the courts cannot intervene in the proceedings of their own volition. So a party has to file an application. As I said, there are two ways for courts to intervene. One is during the course of the arbitral proceedings for interim measures for safety and protection of the assets of the other party. So just the way you go to court to file a stay application, you can do that during the course of the proceedings. Sometimes even before an arbitrator is appointed, there's something called emergency arbitrator. Sometimes parties appoint emergency arbitrator within a span of a couple of days because they want to preserve assets of the other party. So sometimes the court has to intervene at a very early stage in the proceedings. And then once the arbitral proceedings are concluded, award is rendered, and the losing party is not complying with the award, they're not paying the money or they're following the other directions, then the winning party has no other choice except to go to the court where the assets of that business are located. Generally, it's in the country where that business is registered. But a lot of the multinational international businesses, they have assets, in more than one country. So the winning party has the option of going to all of those jurisdictions, which again have ratified the New York Convention, and go to their courts and file a petition for enforcement of the award.
Thank you so much, sir. So as you just mentioned in the answer that, arbitration cannot solely go without the interference of court at some stage or the another. So as per you, can arbitration becomes a future of justice giving mechanism in its own sole purpose of resolving the dispute?
So on its own, as I said that, in an ideal world, arbitrators could function all by themselves without the assistance or facilitation of the courts. That would be party A, party B have a dispute. They've had a long-standing business relationship. They have an arbitration clause. So pursuant to that clause, they appoint an arbitrator, proceedings start. And then once the award is rendered, the losing party has no objection to the award. They fully agree with it, they respect it, and they comply with it, right? So from start to finish, there was no need for the court. There was no need for the court to appoint an arbitrator, because let's say you have an institution which will do it for you. For ad hoc arbitration, it's slightly different. In ad hoc arbitration too, generally, parties can appoint the arbitrator themselves, but if there's a dispute, they can't figure out, who to appoint as arbitrator, then of course they have to go to court. So that is one of the advantages of institutional arbitration. So it makes sense to actually choose an institution that will arbitrate. So then you can avoid the court's intervention as far as appointment of arbitrator is concerned. If you don't need to seek any interim relief, again, no need for the court. And again, once the award is rendered, there's full compliance, there's no objection, no parties disputing it, contesting it. Again, there's no need for the court. But that would be the ideal scenario. It does happen in certain cases. But it's interestingly, we don't hear about those cases either because, remember, arbitration proceedings are confidential. So that's one of the advantages of arbitration, even mediation. Parties that are self-respecting, dignified businesses, they don't want their sort of dirty linen, so to speak, to be washed in the public. So they want all disputes to be resolved in a confidential manner. But the moment you go to court, everything is open to the public because the court is a public forum. Whether you go there for interim measures, whether you go there for enforcing the award, the entire media will be on it. They'll be like, oh, this company, they had a dispute with the other company. So that is something a lot of the businesses don't like. So in those cases, we don't hear about those disputes because they were arbitrated in a completely confidential manner. So it does happen, but it's not that common.
Thank you, sir. My last question to you is, what are the suggestive measures to strengthen ADR in South Pacific Asia?
You mean South Asia?
Yes, sir.
Yes, sir.
South Asia. Okay. Yeah. So, I mean, I can speak for Pakistan, and I think that the trends are similar in India as well. So there's this renewed interest in mediation, especially the past few years. There is some legislation on that as well. Like in Pakistan, they passed this ADR Act back in 2017. Then Punjab, the province where I'm based, they also passed an ADR Act. But I think some of those laws are not very specific as far as, let's say, mediation is concerned. And I think that should be the starting point. You need to have effective legislation which has sort of teeth, which people understand, which is binding, which is mandatory. And another thing that has happened, at least in Punjab, is they've set up these mediation centers, which is again a very welcome development, because it's basically court-annex mediation. Parties are referred to mediation. So that's also a good start. But I personally think that, regardless of how many mediation centers you set up, regardless of how many effective laws you pass, I think the most important thing is for people to understand and believe that mediation, arbitration, ADR are actually effective methods. I think the problem in South Asia, I think, is that people don't understand that the mediation, arbitration, they can actually lead to an outcome which is as good as a court judgment. I mean, yeah, but with respect to the courts, and that courts are superior in that sense. But what do courts do? Courts resolve disputes. Courts resolve it through a judgment. Mediators do it through a settlement agreement. Arbitrators do it through an award. The ultimate goal, ultimate objective is resolution, right? The form is different. One is a judgment, the other is award and agreement. But that is the ultimate goal. So, but I think the reflex or the instinct of people is, let's go to court, or the court, the judge can only decide a dispute. What is this private person going to do? How can a private person decide a dispute, and then what will we do with their decision, right? So that sort of paranoia or sort of lack of clarity, I think that has to be dealt with, and people have to be taught that this actually works. And there are a lot of countries around the world which do this, and they do this very effectively. They save a lot of time, a lot of money, and a lot of times they save their business relationship with the other party. So I think that capacity building, capacity building sounds like a cliche term, it's bandied around, everybody talks about it. But I think if you truly focus on it, it can make a difference. And I think capacity building, again, it's an ongoing process. You can't just organize a couple of workshops and think, oh, people know about mediation. It's an ongoing process. And I think most importantly, it has to be done, or has to be endorsed by all the stakeholders. So capacity building, an institution, our institution starts organizing training workshops, or the Judicial Academy does it, that's fine. But I think if all stakeholders, by that I mean your business community, lawyers community, your judiciary, your government, even your bureaucracy, right? And other industry experts like the engineers, if they all are on board and they all endorse it, and they say, we all have to do it because overall it benefits the entire economy, entire sector, I think that is when people can actually give it more weight, and then understand it, and then start adopting it.
Thank you so much, sir, for agreeing to have this interactive session with us and explaining us the topic so well. I'm sure ADR is now a sort of a preferred practice for resolving dispute, but still it has a long way where everyone could prefer ADR for resolving their all sort of disputes as such. And on behalf of our principal in charge, Dr. Bharati Vidyapeeth ma'am, who is not in the session right now, and our faculty coordinator, Ms. Shivangi Sinha, I thank you so much for agreeing for it. And we do look forward to future contribution as such, and your guidance in our future endeavors, sir.
Sure. Yes, sir, it was a pleasure. And thank you once again for the invitation. I really enjoyed the conversation. Thank you so much for the very pointed questions. I think the conversation becomes interesting only when the questions are interesting. So I'm glad you asked very pointed questions, and I wish you all the best. This is a great initiative, and thank you once again for having me.
Thank you so much, sir.
Yes, sir.